Well, hello and welcome. I hope you can hear me. This has been a while since I've been here. How are you all going? Hope you are going well. Automatically, I'm hoping this is working very well. Let me know if you cannot hear me. Edit mic settings. So, this hopefully is working. Hello. Can you hear me? Let me know if you can hear me. Yay! And can you hear me short order? It's been a while since I've been around. I hope you're doing well. Okay, so I've just seen that there's been some new filings for this. Oh dear, there's been lots here. That's happened. A lot has happened. All right. Oh, that's good. So let's try and work out what we've missed because I've been away for a little bit and there is a lot here. First of all, I hope everyone is doing okay. As you would have seen, there was a tragedy that happened in Australia, a terrorist attack, and it's pretty devastating. Many of us are absolutely devastated by what happened, and our thoughts go out to the people of Sydney and to the Jewish community in particular. So let's have a look here. Hello. Okay, so whoops. Okay, so here we had the order, we had the notice of the hearing. It was taken under advisement, and then there has been all this other garbage that has happened. Look at this. I heard you got the Citizenship Award at school. I did hear that. That's good. Well done. Right, so we're going to try and break this down because this is pretty crazy. So we know that there was a hearing on the 17th of October, okay? So we know about that one. All right. Oh, who told me, Harrison? I know everything. Okay, so then we've got this one here. I'm just trying to see where we got up to. So yeah, there was the hearing, the 17th. So now we've got here, so yeah, so remember they had the hearing on the 17th. So now we've got an amended motion here. An amended motion. So what do they want to do here? So let's have a look. An amended motion. So amended motion and motion for discovery sanctions and reclassification of documents. Oh, they're wanting it all to be reclassified, obviously. So this is interesting. If that is annoying you, the background and stuff, let me know. Right, now we've just got to beat. Oh yeah, that might be better. All right. So Apparently it's lost. Hopefully you can still hear me. It says it's lost my connection to audio, but I think it's only the audio for the screen. So, plaintiffs and attorneys on record. Take note that on December 31st, at 9 o'clock or soon as thereafter, the counsel may be heard before Honourable Kari Willis, Catherine Mansky-Polson, and without a crystal ball, will move the court for the following relief. Sanctions for spoliation of evidence, including corrected affidavit, targeted searches of social media archives, production of undisclosed accounts, adverse inference instructions, preclusion of damages claims based on destroyed evidence, and attorney fees. Removal of improper and confidential designations, including all attorney eyes only designation. No, I'm not. Is that painful? Is that better? Is that better now? I'm not on my phone. I should be on my computer. All right. Designations and blanket deposition transcript designations. Sanctions for failure to produce court-ordered financial discovery, including preclusion of damages claims based on low social media income or alternatively, reopening discovery for 60 days. Reopening discovery for 60 days for depositions of Hannah Shin, Shirley King, and Robert Shin regarding newly discovered evidence, or alternatively, adverse inferences and preclusion of testimony, such other relief as the court deems just and proper. The amended motion is based on the accompanying supplementary and reply memorandum of law, the 10th declaration of Jennifer Moore, with attached exhibits, prior declarations and pleadings on file, and such further evidence and argument as may be presented at the hearing. They're still trying to get this new evidence in. Now, does she realise that if they take off all the designations for attorney eyes only, that then hers becomes open? Does she realise that? Because do you think the judge is only going to make their stuff attorney's eyes only and not hers? Or is she that stupid? So that's the notice of hearing. Okay, so now we've got the memorandum. Here is their... This is 14 pages long, by the way. 14. Okay. Plaintiff's temporary motion for temporary injunction is not merely defective. It is constitutionally impossible. What? Oh, I don't know. That's old. No, sorry. That's old. We've already done that. Okay, sorry. I'm getting confused because there's so much garbage. There's so much here now. I shouldn't call it garbage. Now I think someone was saying that she thinks it might be because there is a part 2 doc. She needs all of the info public access so she can use it. Aha. Yeah, but if it means, but they're going to, it also means that all of her information will be available as well. That means that her financials, the judges, I can't see the judge saying we're going to take off the confidentiality clause only on one party. What I think will happen is that if they're going to take it off, they're going to have to open it up both sides. That's my belief. And does she want everybody to see her financial documentation? All of her private stuff? Remember, it's about justice and being just and fair. And it would be unfair to release one side's information and not the other side's, by the way. So this memorandum addresses ongoing discovery disputes revealed through November and December 2025 correspondence and provides court with a complete record for the December 31 hearing. Defendants' motions addressing discovery sanctions were originally noticed for hearing on October 17 before the non-dispositive motion deadline. That hearing was continued to December 31. Following defendant's September 26 opposition memorandum, which raised discovery compliance issues, defendants attempted to resolve these disputes through meet and confer rather than requiring the court to rule on pending motions. But I thought the court preferred meet and confer because that way you're trying to save court costs, by the way. On November 14, defendants sent a detailed letter proposing a reasonable resolution to confidentiality disputes and spoliation concerns. The letter requested a telephone conference to discuss these issues, offering to withdraw or hold pending motions in abeyance if parties could reach agreement. Plaintiffs responded on November 21, rejecting all proposed resolutions. Parties then suggested a meet and confer for December 5. Following that call, defendants sent a letter memorializing the discussion and areas of agreement. Plaintiffs responded by email the same day. The November-December amended correspondence revealed new issues and deepened existing disputes. Defendants now filed this amended motion on December 10 to provide court with the complete record of these developments, including material contradictions between sworn affidavits stating accounts were deleted and counsel's representation that they were deactivated. Plaintiffs' refusal to search social media archives they claim to possess. Plaintiffs' assertion of a procedural deadline for challenging confidentiality designations that doesn't exist in the protective order. Plaintiffs' concession that social media monetization records are responsive immediately after claiming dispute requests were too vague to seek such records. Plaintiffs threatened to contempt motion despite the non-dispositive motion deadline having passed. The non-dispositive motion deadline has now passed. Plaintiffs have threatened contempt motions in their November-December 25 correspondence, but these threats are procedurally barred. Plaintiffs cannot seek affirmative relief after deadline expired, particularly when they remain in far worse violation of the same court orders they evoke against defendants. The contradiction, the deleted, deactivated contradiction. I mean, all right, so just a side here. Are we playing on semantics here? Like, is this semantics? Would the average, right? Here's the thing. The average ordinary person, would they believe deactivation and deletion was the same thing in reference to a social media account? We're not talking about what a bunch of experts says. We're talking about what, remember, it's what the average jury member would think. So in their mind, if you have said that you've deactivated your account, would they think that the account is deleted, or would they think that it's deactivated, or would they not really, or would it just mean in their mind that it's deleted, it's no longer there? Can you see my point? We're talking about the average person. We're not talking about people that know that experts. All right, we're just talking about the ordinary user, the ordinary person. Miranda said that she deleted her presence, didn't she? Her account. Well, yeah, well, that's right. I mean, as I said, it sounds like we're really getting into semantics, and this is my point. Can you argue that it's the same thing because her presence isn't there? So if you are no longer on social media, can you say that it's deleted even if you deactivated it? your presence is deleted. If you're no longer there. Anyway, as I said, we're getting into semantics. Plaintiff's October 8th sworn affidavits at paragraph 3 says, I deleted my social media presence as a result of the backlash from the defendant's increased aggression. M. Derrick. Both Miranda Derrick and James Derrick sworn this under the penalty of perjury. At the hearing on the 17th, and in correspondence dated 21st November and December 5th, Ms. Stagford stated that her clients did not delete the social media account, but rather they deactivated the accounts and their archives are fully preserved. There are two problems with this assurance. First, Ms. Stagford's representations are not admissible evidence. Second, while the archives were preserved, they are not available to Ms. Paulson. In the effort to resolve the issue, Ms. Paulson requested that the Derricks amend their affidavits that their social media archives be made available to defendants. But hey, when did Katie Paulson become the judge to decide what the defendants needed to show? So they say that they've deleted. Oh wait, what did they say? They deleted their social media presence. So if you've deleted your social media presence, does that imply that you've deleted your account, or that have you just removed yourself from social media? This is the question. This is the semantics. It's a pretty big hill to die on, in my opinion. As an alternative, defendants provided Ms. Stagford with a list of... the plaintiffs, sorry. But since when is it up to Katie Joy as to whether the plaintiffs amend their stuff? As an alternative, defendants provided Ms. Stagford with a list of targeted search terms designed to ensure that all relevant information was preserved. Ms. Stagford again refused, making the somewhat outrageous claims that the defendant are not entitled, on the record before the court, to obtain discovery regarding statements the plaintiffs have made about the defendant or about claims in this lawsuit. In fact, more than 3 years ago, defendants served discovery requests requiring plaintiffs to preserve and produce precisely this material. And then they've got that. Now, here's the thing, right? We're now going to have to now we have to go waste our time and go back to see what the judge actually ordered, because remember she didn't get all of her discovery requests. This has been forgotten. She didn't get all of her discovery requests. Yes, they requested it, but was the request granted by the court? They haven't said that. Despite this clear record, Attorney Stavek's December 5, 2025 email asserts that Exhibit A appears to be an attempt to request additional documents that were not asked for during discovery, and demands defendants provide discovery requests relevant to your request for these search terms. The requests are Interrogatory 11, Request 2, 5, and 19, served in August 2022. And court ordered on January 29, 2024. But even they hadn't been produced to them at that time, plaintiff's deletion or deactivation of their social media accounts mean the information that used to be arguably available to the public is no longer available. But I'm also certain that they would have preserved them and that would be available to the court upon request too, by the way. The undisclosed accounts. Oh, this is a horrible hill to die on, by the way, because you know what? If they're going to, and I'm not even reading, I'm just reading the headline, the undisclosed accounts. Now, if she's implying that there's undisclosed social media accounts from the Derricks, I'm certain that there'll be a whole list of social media accounts that are alleged that Katie Joy's responsible for. Could you imagine getting a list of her sock accounts? The contradiction about the main Instagram TikTok is not isolated. Two other social media accounts were responsive to defendants' August 22 discovery requests, but have never been disclosed. The Wilkins Systems 2 Instagram account containing videos of Miranda Derrick discussed in the lawsuit, and Without a Crystal Ball or Clue Instagram account. maintained by Robert Shin and all 7M Films, publishing statements about this lawsuit. Defendants first raised these accounts in July 2024. Correspondence. Plaintiffs have never responded. Not a confirmation or denial that the accounts exist. Not an identification of ownership, not a statement about whether they were included in the August 15, 2025 deletion deactivation, not even an objection. The court cannot evaluate spoliation without knowing what accounts existed and what happened to them. Plaintiffs' silence about these accounts while simultaneously claiming they deleted or deactivated their social media presence suggests they're hiding the full scope of their social media activity and demonstrates a pattern of bad faith concealment. Under Miller versus Lancro, courts considered the degree of fault, the prejudice to opposing party, and whether the less sanctions suffice. Fault. Plaintiff eliminated their social media presence on August 15, 2025, years into litigation. After targeted discovery requests, after court-ordered production, they concealed the existence of additional responsive accounts for over 3 years. They provided contradictory sworn testimony about deletion versus deactivation. The timing and contradictory explanations demonstrate bad faith. This is a defamation case about social media reporting. The social media content is the primary evidence of followers' counts, engagement rates, brand partnerships, monetization, and accuracy of Paulson's reporting. Without complete disclosure of all accounts and their contact, defendants cannot evaluate plaintiff's $4.7 million damages claim or defend against defamation allegations. Really? If she say, wow, if additional accounts existed and discussed in this litigation or contradicted plaintiff's sworn testimony, that evidence is directly related to actual malice or truth defense. You've never pled the truth defense, Katie. You just can't now start saying that you're going to start using the truth defense. What on earth? You've never mentioned the truth defense. You've been dying on the I'm a journalist hill. That's been your defense. Since when has she started talking about the truth? You now just can't throw in new defenses. Until plaintiffs clearly clarify under oath whether accounts were deleted or deactivated, disclose all accounts existed, and explain what happened to each account, the court cannot determine appropriate sanctions. So they want corrected affidavits within 7 days, clarifying whether main Instagram, TikTok accounts were deleted or deactivated, while archives exists and in what format, whether archives can be searched. This is discovery again. If original affidavits were wrong, why? Whether Wilkins sisters too and without a crystal ball or Kulu accounts exist or existed, who owns control these accounts, whether these accounts were deleted on August 15, 2025 or at any time. This is new discovery. I think it's because they don't see her as a journalist. She's trying, she's already put her defense in short order. She's responded to the defense. Her defense is that she's a journalist. You can't change your defense halfway through. That's why often they will often in defamation cases they will list 4 or 5. There'll be 4 or 5 defenses because one of them most likely sticks. But she only ever talked about the truth. She only ever talked about being a journalist and her protection under the Constitution. So run targeted searches from defendants December 5 later against all archives within 7 days, or file sworn affidavits explaining why they cannot produce content from undisclosed accounts, including on posts, comments, metadata, and particularly content about this litigation, defendants, the Wilkin family, or the federal investigation. And why are we bringing in the federal investigation? The federal investigation has nothing to do with the original defamation claim. Adverse inference instruction that destroyed or concealed social media evidence would have been unfavorable to the plaintiffs. Again, you can't just put new evidence in. Everything in this defamation case relates to what was there at the time, not what is known now. Preclusion of damages claims based on lost social media income vote when plaintiffs eliminated or concealed evidence of that income. Attorneys' fees for time spent addressing contradictory statements, seeking spoliation evidence, and attempting to obtain disclosure of accounts plaintiffs should have disclosed in August 2022. Plaintiffs designated entire deposition transcripts of Robert Shin, Miranda Derrick, and James Derrick as confidential, without line-by-line justification. Deposition testimony is presumptively public under Minnesota, with the burden on the designating party to prove good cause for specific confidentiality restrictions. Okay, question. Why can't we see Paulson's deposition transcript, by the way? Plaintiffs designated the vast majority of financial documents as attorney's eyes only, preventing Paulson from reviewing them under the protective order. She doesn't need to see them. The investigation has nothing to do with this case. I think her new evidence is speculative, if any. She's just trying to bring that case into her. Yes, and that's what she's trying to do, is link the two cases so that she can say, yes, I was right. Is limited to especially sensitive information, including private financial information, sensitive and business information, medical records, and personal contact information. The designating party bears the burden of proof of providing materials fully within this scope, and that disclosure to the opposing party would cause significant harm. Well, we know what will happen if it gets into the to Paulson's hands. Why Paulson needs access? Paulson has specialized knowledge about social media monetization that her attorney does not possess. As a content creator, she understands payment structures, brand partnership, economics, and financial relationships between creators and management companies. This expertise is essential to analysing the September 2025 financial production and preparing her defence. You don't mean to tell me, you are telling me that her lawyers cannot find an expert in monetization, an independent expert on monetization that could analyze this for her and make their points credible, but rather it has to be Paulson, that she's the only one that's specialized to do this? So you're telling me she's the only one that can do this? The financial documents were produced 19 months late. Discovery had closed. Paulson now needs access to assist counsel in preparing defense strategy, identifying relevant documents, and understanding what financial records reveal about the accuracy of her reporting. What does hilarious. She has more expertise than everyone there: judge, lawyer, accountant, media mogul. Because surely there is somebody that you could call in, an external, an independent expert that could do that analysis for you, and it would be credible. Oh, that's hilarious. So now this, what does financial records? So if the financial records, so they want, what she wants to do, she wants to see if they've lost money, so she can say, see, my reporting didn't do it. Oh, she even throws her lawyer under the bus. Yeah, so she's essentially saying her lawyer is incompetent. Plaintiff's November 21, 2025 letter asserts AEO designations are justified because Paulson has demonstrated a history of publicly disseminating plaintiff's private information. The letter cites Paulson's July 25, 2025 Instagram post about marriage certificate and her comments about Derrick's demeanour during depositions. Paulson has posted public records obtained independently from government sources, including marriage certificates and addresses from public record databases. I thought she didn't dox anybody. She has posted court documents from other litigation, where she's not been subject to confidentiality orders. She has commented on deposition demeanour based on her own observations. None of this involved breach of protective order in this case, which only governs materials produced in this litigation. The marriage certificate was materials produced in the litigation, you driphead. So here, have a look here. Posted public records from government sources, including marriage certificates and addresses from public record databases. They admit that she doxes people. Oh dear. Unbelievable is all I can say to that. Unbelievable. They've just admitted to doxing. Hey? There is so many documents here. It's not funny. And we know that she posted they posted something about it. Yeah. So they have literally admitted to doxing. They have admitted to doxing. I think some of the documents are repeats, yeah. The protective order provides 2 levels: confidential, accessible to parties but not for public disclosure and attorney's eyes only, accessible only to counsel. Confidential designation already prevents Paulson from publicly disclosing financial documents addressing any concerns about public dissemination. AEO is reserved for rare situations where disclosure to an opposing party, even under strict confidential obligations, would itself cause significant harm. What harm would result from Paulson seeing 7M's financial documents under confidentiality restrictions? Anyone want to answer that? We know. Plaintiffs only offered generic assertions about sensitive business information that would apply to any financial documents in any commercial litigation. They identify no competitive disadvantage, no specific harm, no reason why confidential is insufficient. Stavag's December 5, 2025 email claims paragraph 7, 30-day deadline makes defendants' challenge untimely, and with a footnote. Plaintiff's pattern of non-communication has driven much of this case's procedural chaos. Despite defendants' June 24 correspondence, including specific inquiries about discovery deficiencies, plaintiffs did not respond. Plaintiffs never advised defendants they intended to file for summary judgment. Then, after the court ruled on summary judgment and granted defendants leave to seek reconsideration, plaintiffs ambushed defendants with supplementary discovery and a second injunction motion based on social media content never previously identified to counsel. Plaintiffs may claim such communication would have been futile. The record proves otherwise. Defendants have repeatedly asked plaintiffs to identify objectable content in writing. Plaintiffs have never complied. All right. Paragraph 7 states the party seeking redesignation shall, within 30 days of the request, move for the court for appropriate relief if the parties cannot agree. This is the deadline for seeking judicial relief, not a statute of limitations eliminating all rights to challenge designations. Defendant's timeline: September 26, 2025, memorandum challenge designations, October 17, 2025, motions properly noticed, continued to December 31. November 14, meet and confer letter. November 21, rejection by plaintiffs. December 10, amended motion. Defendants have consistently sought judicial relief. Paragraph 7 states the party asserting that materials confidential or highly confidential shall have the burden of proving that the information in question is within the scope of protection is backwards. The burden is on the plaintiffs. So they want requested relief. Remove all AEO designations. Documents may remain confidential, allowing Paulson access or preventing private disclosure, public disclosure. If plaintiffs believe specific documents warrant AEO identity, identify them by Bates number with sworn declarations proving AY, especially sensitive under 2, what significant harm would result from Paulson's access under confidentiality restrictions, and see why confidential designation is sufficient. You know what she'd do? She'd tell a friend who'd tell a friend who'd tell a friend. That's how she does it. De-designate deposition transcripts, especially for genuine private information. If specific testimony requires confidentiality, identify by page and line number with justification. So, here we go. The court-ordered financial discovery, 22 months and counting. The court ordered plaintiffs to produce tax returns and financial statements, documents showing compensation attributed to social media activity, compensation from butch performances, and compensation paid to 7M dancers with withholdings. I thought they only had to do that for 7M. These requests go to the heart of plaintiff's $4.7 million damages claim, which is substantially based on those social media income and brand partnerships. Nothing happened for 19 months, no production, no supplementation, no request for clarification. Finally, in September 2025, plaintiffs produced 7M's tax returns and financial statements, some payout schedules, and brand partnership invoices. The timing was strategically late enough to prevent follow-up depositions or expert analysis, but enough to claim compliance before sanction hearings. Now, interestingly enough, remember, 7M is no longer operating, so they may have been needing to come from other areas. I'm just there. The critical cap, platform monetization. Plaintiffs produced invoices showing that they were billed for brand. They sponsored for brands for sponsored content. They produced nothing showing what social media platforms paid them directly. Social media creators earn income from two main sources: brand partnerships, documented in the invoices plaintiffs produced, and platform monetization. The payments: Instagram, TikTok, Meta, Facebook, and YouTube. Isn't Meta and Facebook the same thing? Make directly to creators based on content performance. These platform payments include creator funds, creator rewards, real play, bonuses, stars, ad revenue sharing, and similar programs. Platform documents these payments in monthly earnings statements and annual tax forms. Without platform monetization records, defendants cannot verify how much income the Derricks actually earned from social media and what income it declined due to Paulson's reporting. Well, if they don't have social media, isn't that a decline? And other factors such like algorithm changes or how money flows between the Derricks and 7M. That's the crux of it. The structure of these payments, whether platforms pay the Derricks directly or route payments through 7M, is direct evidence of financial relationship Paulson reported on. Also, missing bank records showing receipt and distribution of income. Invoices show what was billed, not what was paid, where it went, or how it was split between 7M and the Derricks. During the December 5, 2025 meeting conferred, defendants raised the missing platform records. Attorney Staffak's email's response began, "You did not request social media monetization records in discovery. Your requests for production are vague and only state documents sufficient to show compensation. Your vague request does not equate to the request for social media monetization records. During our conversation, you also stated that during their depositions, my clients James and Miranda were not aware of these monetization reports. This statement is false. In fact, I stated that the Derricks were unable to testify with any specificity about these reports, but they did testify generally about the revenue streams. Ms. Derrick testified extensively about earning income from social media platforms. When asked as a social media content creator, how do you make your money? She answered through brand deals. When asked whether she made any income through any other brand deals, she said yes, and identified it from views on Instagram. She answered detailed questions about how 7M collected payments from brands and issued statements showing her earnings. James Derrick similarly testified about earning money through brand deals and answered questions about income from Instagram. Ms. Stavak was present for both depositions. Her clients understood exactly what monetization meant: platform payments from Instagram, TikTok, YouTube, and similar services based on content performance. They testified about it under oath, even if Ms. Stafford was unaware how her clients earned their money. The Derricks knew. Stavak indicated she would provide these documents, but is yet to comply. The 19-month delay prevented follow-up depositions, expert analysis, and additional discovery before discovery closed. More fundamentally, plaintiffs claim Paulson's reporting about financial control was false, and it cost them millions. If true, financial records proving independent contractor relationships and transparent income flows would vindicate them. Instead, plaintiffs withheld financial records for 22 months and still have not produced platform payment records showing how income actually flows. Wouldn't that appear in the financial records of 7M though? Because if 7M had received the money from like Instagram or something and then had paid the Derricks, wouldn't that be shown in the financial? Wouldn't that appear in the financial records? So you wouldn't need to see the others. And if it doesn't appear, then you would assume it went to the Derricks directly, which means you wouldn't. Which then answers your question, wouldn't it? Maybe I'm just like, I don't know, I'm losing it. Preclude damages based on low social media income unless plaintiffs produce within 14 days complete platform monetization records from all platforms showing monthly payments from January 2020 through to present, bank records showing receipt. This is again they want more discovery. Bank records showing receipt, distribution of all social media income, any agreements between the Derricks and 7M regarding income sharing and management fees, documentation of withholding and splits. If plaintiffs cannot or will not produce these records after 22 months after court ordered them, they cannot prove damages. The court declines to preclude damages, then reopen discovery for 60 days to permit follow-up depositions about September 25 financial production, and if any belated produce platform records, expert analysis and subpoenas to platforms if necessary. Adverse inference instructions that platform records would show less income than claimed or structures inconsistent with plaintiff's narrative. Order compelling production within 14 days with progressively stronger sanctions for continued non-compliance. Attorney fees for 22 months of attempting to obtain court-ordered discovery. Short order says, KJ, I don't think believes that the money, the Derricks own, went straight to them, because if it did, it would blow her story on Shin controlling their money. And that's the point, though, because if Shin was controlling the money, wouldn't the money be shown going through 7M and then out again? And if it's not, then that's the story blown. I mean, the only then allegation you would have is, if it doesn't show it, is that the records are faulty or falsified, and then you've got a whole nother argument. But they've not even said about the fact that the records could be falsified. They're saying that, but as I said, if the financial records that they would see would surely have shown, you would see where the money's gone. Discovery closed months ago, but evidence didn't stop coming. On July 25, federal agents raided, here we go, Robert Shin's properties in California, according to a public forfeiture notice issued by the U.S. Postal Inspection Service. On September 9, federal agents seized $105,000 in cash from Shin that day. Money they claimed was connected to a violation of federal law. Plaintiff's own California attorney filed a sworn declaration in their related litigation acknowledging he'd received the forfeiture notice and referencing a pending criminal action. Meanwhile, back in Minnesota, plaintiffs were under oath that no criminal charges had been made. A carefully worded statement that conspicuously avoids addressing whether investigations exist. That's not the question! You can be investigated and have no charges laid, you idiot. They built their whole entire injunction motion around the premise that Paulson's reporting about federal investigation is false and defamatory. Both stories cannot be true. The documentary evidence, public records filed in court, issued by federal law enforcement, proves that the investigation exists. Defendant needs depositions to explore what these records mean. They were correct. Meanwhile, back in Minnesota, plaintiffs swear under oath that no criminal charges have been made. They didn't say no investigation has occurred. They said no criminal charges has been laid. Seriously. Like, this is doing my head in. What? How is that false? And as far as we know, is has there been charges laid? I haven't heard anything to say that there's been any charges laid to date. There's still no charges laid. That statement still exists. No charges. She's not happy about that after all the work she did to try and get him raided, arrested, and thrown in jail. You can have an investigation and still not have enough evidence. The September 2025 financial production revealed that Hannah Shin appears as a shareholder in 7M Films and throughout the financial records in contests, suggesting significant corporate authority, and that Shirley Kim is closely tied to 7M's business operations. The production also disclosed that Hannah Shin sent Kylie Douglas's termination text. In their 14th February 2023 Rule 26.1 disclosures, plaintiffs identified both Hannah Shin and Shirley Kim as individuals with discoverable information regarding the facts alleged in plaintiff's complaint and defendant's answer listed available through counsel Amber certificate. Despite this early identification, nearly 3 years ago, plaintiffs never made either witness available for deposition during discovery. If plaintiffs have complied with the court's order on January 29, 2024, and produced the financial records timely, defendants would have seen the extent of their involvement and noticed depositions during regular discovery. Instead, the 19-month delay concealed their roles until discovery had closed. So, hang on a minute. So now, are we saying that Shin wasn't the controlling person of 7M? Robert Shin was deposed during discovery. Sorry, I'm really tired. I've had a long day and late night shopping's about to start. The Christmas crazy time's about to start, so I'm all over the place. But before that, before the September 2025 financial production and the July 2025 federal raid and the September 9, 2025 forfeiture notice showing 105,222 seized from him, and the October 8, 2025 declaration from his own California attorney acknowledging the criminal investigation, she needs to be redeposed about these developments. Yes, he may invoke the Fifth Amendment, but that's his right. But defendants are entitled to ask the questions and establish a record of what he will and won't answer. What has the other court case have to do with the current defamation case? And what has pending criminal charges got to do with the current defamation case? Because remember, at the time she said those things, was there an investigation happening? And remember, it's about the time that it's about 3 years ago. It's not about what we know now. When she said these things. Reopened discovery for 60 days, limited to depositions of Hannah Shin, Shirley Kim, and Robert Shin. Scope, role at 7M, corporate structure, financial relationships. The September 2025 production, the July 2025 raid, the forfeiture and non-privileged aspects of the federal investigation. No other discovery reopened. Alternatively, if reopening is denied, defendants request adverse inferences that testimony from witnesses would have been unfavourable to plaintiffs, preclusion of their testimony at trial, and the admission of the forfeiture notice and Gutton Plan declaration of substantive evidence. So now they want to put in the evidence. Yeah. Plaintiffs have systematically violated court orders, destroyed evidence, concealed responsive accounts, and obstructed discovery for years, while simultaneously seeking to silence defendants' constitutionally protected journalism. See, we're back to constitutionally protected journalism. We're back to her. Right? The contradictions between their sworn statements in Minnesota and California, the spoliation of social media evidence central to this defamation case, and the 22-month failure to produce court-ordered financial records warrant the sanctions requested. All right, so then we've got that, okay? That is just... And then, this I find this to be really interesting. Then there's a confidential information form that was listed. And then there's a proposed order or document. That is, what is that one? That one is, I think I downloaded that one. Other document, what is it? No, 12. Memorandum. Alright, so then we've got this one. She won't be happy until she's okay, so then we've got this one. So this is the proposed order. Court makes subject matter justification over underlying action. That they order defendants receive actual notice of court orders, made multiple requests, counsel met and conferred, yet plaintiffs applied for court assistance, yep, blah, 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 blah. Court has authority, yep. So they want that, they want the defendants found in civil contempt. That they shall hand over everything. So that is the proposed order. If they fail to meet the deadline, they pay $50 per day. Blah, 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 blah. Okay? So that's what they would like. That's what they are requesting. It's just a proposed order. Okay? And then we have the next thing. Okay. So now they have 7M then responded with their own motion. So they've gone, the defendants take note that on Wednesday that Robert Shin and the party finding defendants contempt for failure to comply with paragraphs 8 of the court order of the motion to compel. So that the paragraph 6 through 9 of the order requires defendants to produce tax documents requested in plaintiff's requests, as well as additional interrogatories and requests for production of documents. This is getting dirty. The court held that defendants must produce tax records for Catherine Mansky-Polson and without a crystal ball from January 2020 to present, and determined that the requested financial records are discoverable because the issue of whether defendants were compensated, how much they were compensated, and whom they were compensated from January 2020 to present is relevant to defendants' motions in discussing plaintiffs on social media platforms, including the depth, length, and substance with which the plaintiffs were the focus of Ms. Polson's discussions. Despite this clear directive, defendants have willfully failed to obey the court's order and continue to withhold the required tax documentation and other compelled discovery. Have a great night, short order. That's all right. We'll just keep plugging through, and I'm sure people will watch us on replay. Stay safe, short order. So this motion is based on a company memorandum of law, blah, blah, blah. So this is what they're fired back. So remember that this has been, oh, wait on. Can you talk about what Kjoy has done that doesn't fall under guidelines of free speech? Look, you can talk about anybody. You can say what you like about anybody, but it has to be an opinion, okay? You know. Or you can back it up with some type of evidence and fact. So this is Jennifer Moore's affidavit here. So what I'm saying is that when she talked about Robert Shin waterboarding or the human trafficking parts of that, she stated stuff as fact. You can state stuff as fact if you can back it up. There are more and more reporters at the moment having to, particularly in Australia, having to go to court and show the reveal where they got their sources from. See, Australia doesn't have a constitutional right for freedom of speech, by the way. We don't have that in our constitution. So this is the letter. Yes. So 7M's basically saying that. And the thing is, defamation by definition is something that is said about somebody else. So something is said to somebody else, to any other party, about somebody that isn't true, that lowers your opinion of them. So if I say, for example, if I was to make a comment about the Prime Minister of Australia, for example, and if I stated that as fact, he technically could sue me for defamation because I may have had people lower their opinion of him regarding him. But often I will say is my opinion, or people have said, or the general view is. So at the moment, with this terrorist attack, there's been a lot of criticism about Albo and his government about being weak. There's a lot of anger around. Now, by the way that I phrase that, I have said that there is a lot of commentary. A lot of people are saying that. I'm not saying that. I'm just repeating what other people have said. Oh, look, this is all of it. This is joke. Objections to letter. Yeah. See, if she had said, "It is my opinion, and I don't know for sure," that wouldn't be defamation, because she's saying she doesn't have the information to be able to say whether it's true or not. Remember that you can only be, you're innocent until proven guilty. No, that's all right. I don't look. Defamation cases are generally very, very hard to win in the scope of it. Usually, they will. From what I've seen, a lot of the media, the ones that in Australia, will run 3 or 4 defences. They'll do opinion commentary. They will do truth defence. They will do. They will talk about qualified privilege, which is, we've been told by somebody, but we can't tell you, and we've got some protection for it. Or they'll talk about, so they'll run 4 or 5 defences, knowing that one of them may protect them. But Katie Joy's only used the journalism defence to say that she's a journalist, and that's where I think her biggest weakness is, because if the court doesn't find her to be a journalist, right, then she's essentially got nothing, no other defences in the court. I think I personally think it's silly. You want to have 3 or 4 defences. And she could have easily have done the truth defence, and she could have used the evidence from the documentary or something as her truth defence, or interviews with the people, but she didn't file the truth defence, and she's just put it in this last document about the truth defence. But you just can't keep changing how you defend yourself. You just can't. You just can't keep adding new defences. So I'm just opening up all these windows, and we're just going to see, like, there's a whole pile of them here. They just keep going and going and going. Affidavit of attorney. I don't know that I'll get to all of them tonight. As I said, been pretty flat out at the moment. So, and because Katie Joy has made this big song and dance about they haven't produced Discovery. Well, 7M have said, well, that's all right. You wanna play that game? We'll file the same thing now, and it's going to be before the court. So it's really quite interesting. So then they've filed this, which I find to be really interesting. Plaintiff's first set of requests. Take note that in accordance with rule, you've got to request in writing and produce all responsive documents and tangible things for inspection within 30 days. This was filed on the 12th. And the definitions here, your identity. So they want lost or destroyed documents. Yeah, so this is to Katie. So 7M has said we want lost or destroyed documents and procedure for claiming privilege or other objection. So they want all the documents. So they've refiled their requests. Oh no, that's from the 2023. That's what they asked for in 2023. But they've refiled that to say, hey, we've asked for all of this. This is objections from letter. I did not agree to you to send any targeted search terms for my client's social media accounts. I asked you to provide the discovery response which authorizes your request. This Exhibit A appears to be an attempt to request additional documents which were not asked for in discovery. Please provide relevant discovery requests. As to the News Nation issue, your client is compelled by the court's January 29, 2024 order to respond to our interrogatory, which states the name, address, and contact number of each and every person to whom the defendant shared information with regarding 7M Films, Robert Shin, Miranda Derrick. So they've gone and it says you have failed to provide this information. News Nation is just one institution Miss Paulson shared information with. She was an archival consultant on a Netflix documentary, and no information about who she spoke with was given to us for that either. We'll be filing a motion for your contempt to complete. As for your request regarding deactivation, I've already clarified that their accounts were deactivated, not deleted. They still have access to them. I made this correction on the record. Oh, wow. So anyway, and it says, Miss Kim and Mr. Shin are not my clients. I cannot compel individuals who are not my clients to do anything. That is true. She's representing 7M. And then 7M has put this down as in their evidence. I think, is this 7M's evidence? So they've 7M's not playing games anymore. Oops, my screen's just died. Can you believe that? My screen's just died. There we go. So Amber has done her affidavit. Yours isn't flickering. Mine's flickering. So they're talking about all the requests here. My screen's about to die by the looks of it. Yeah. So yes, they've talked about yeah, so there's lots of documents here that are being put into the court. So yeah, so this one's one of them where she's talking about it. And News Nation. Yeah, that's attachment 3A. YouTube video and accompanying transcript claiming she has dozens of clips of plaintiffs that she describes as evidence that she'll be able to use when they go to trial. Remember, you just can't put evidence in for the sake of putting evidence in either. Like, it just does not work like that. Just does not work like that. All right, what's this one? Oh, I didn't want that one to open. Hang on, here we go. What's this one? Oh, yes, this is the transcript of the video. This is one of her transcripts from one of her videos. I don't know what this has got to do with it, but anyway. Oh yeah. Oh yeah, here we go. Something. The jokes have gone radio silent. This is the pattern with Robert Schindler. People are very concerned right now. He has this history of deleting evidence when he gets stuck into situations where he might face legal action. And when we made the Netflix docuseries Dancing for the Devil, if you recall, Nicholas Rayner, his parents were on that. And Nicholas's entire social media was wiped out like the same day that everything went on Netflix. And so much like what he's done with Nicholas Rando, we think he's pulling Miranda and James off the internet, so there's no trace of them if and when he's arrested. This is a pattern to try and conceal evidence. Now she said, in my opinion, and to say people concerned is an understatement, because James and Miranda have spent years building that audience. I mean, this was blood, sweat, and tears. So anyway, yes, that's all of that. And then she's talking about that. But yes, she says in his opinion once, I think. So look, there's a lot of documents going back and forth. This December 31 hearing is going to be very, very interesting. Because both now have filed motions to compel and for contempt. And it's going to be interesting. The judge has to somehow wade through all of this. And I don't know how she's going to do it. That's why she gets paid the big bucks, being the judge. Because it would seem, for me, in my opinion, it would seem that both sides haven't complied with orders. Now, either the judge will just sanction them both sides, and say, hey, you've both done wrong here. Or she's going to make a decision as to what side. And let's face it, Katie Joy was required to... she was court ordered to produce documents. We know that. So, yeah. Anyway, my computer's just decided to play up again. So I think I'm going to have to love you and leave you, maybe. So look, thank you for watching. Hit like and subscribe. I'll try and come back on later. I've been pretty flat out. Selling calendars. I'm breaking the budget. When I say I'm breaking the budget, I mean I am literally going over the budget that they've set for me. So much so that they keep having to send me new more and more stock, because apparently I'm selling out of everything too quickly, which is really good, because there's a bonus at the end if I hit my budget target, and I keep hitting it, and I'm happy about that. But I've got a good team that I put on a good team. I wanted to see if I could do it. I did it. It wasn't without challenges. I did have a meltdown. People saw the worst of me, and and now I'm doing what I'm great at doing, managing people and talking to people, and apparently I'm really good at selling calendars. So I can lots of different calendars. Anyway, thank you for watching, and I will catch you next time. Hopefully, we'll have, it won't be so long before I'm back on. But thank you, everybody, and I will see you again another day. I just seen what's here. All right. Yeah, I'll see you again soon, hopefully. Bye for now.